Good morning. Happy Saturday. I was busy recording a previous version of this and I got something in my throat and I've been coughing a bit. So if I start coughing again, bear with me. It's not COVID. It's something like a piece of plant fiber in my throat. I don't know. Anyway, it's like 2:30. Might be getting close to 3 o'clock now in the morning. Couldn't sleep, can't sleep, tried to sleep. So I figured that I would get up early and walk the dog and talk to you about strategic lawsuits against public participation. Now, what is a strategic lawsuit against public participation? And no, don't worry, the whole video isn't going to be on SLAPP. But a strategic lawsuit against public participation, henceforth referred to as a SLAPP, is where somebody will sue you to shut you up. They don't have any real chance of winning. They just know that, or maybe they don't even sue you. Maybe they just threaten to sue you, but it's designed to shut you up. Lawsuits are expensive, and lawyers know how expensive lawsuits are, and lawyers very rarely tell their clients up front that if they want to sue somebody, and it's not a contingency basis, that they're looking, on average, probably $25,000 for a average lawsuit. Average state court lawsuit, $25,000 easy. It can get way more expensive too. I have seen litigation costs rise over $100,000, and it's not common, at least not in the area where I have been in, not in the lawsuits I have been a party to, but it can get pretty expensive. And most people, when faced with the alternative of retaining a lawyer and trying to fight this, because most people aren't going to be willing to devote the amount of time it takes to try to figure out even the basics, the procedural hurdles that you have to face to defend yourself in a lawsuit. What kind of answer to file? Do you file a cross complaint? Do you file demur? What's the difference between a motion for summary judgment and a motion for summary adjudication? Most people aren't going to want to take the time to figure all that stuff out, so they're going to have to hire an attorney because they've got jobs and families and things like that. And so just holding the threat of a lawsuit over their heads can stop them from doing the thing that we want them to do. And what we want them to do is we want them to be able to voice their opinions. We want to encourage people to speak. The First Amendment, all that fun stuff. We don't want people using the courts to try to deter otherwise legal, legitimate, and beneficial behavior. So most states that I'm aware of, I'm sure somebody somewhere will find a state that doesn't have an anti-SLAPP statute, but most states, at least all the big ones, at least the ones I've looked at, have anti-SLAPP statutes. And basically, it doesn't mean that those lawsuits can't be filed, but what happens is, at least in California, if somebody files a lawsuit, let's say they're alleging intentional infliction of emotional distress, you can file what's called an anti-SLAPP motion. You could say, this is really an attempt to shut me up. This is really a SLAPP, a strategic lawsuit against public participation. They're just trying to shut me up. And then, if the judge agrees with you, then what it does is it shifts the burden of proof immediately to the plaintiff. The plaintiff has to prove that by a preponderance of the evidence, that I think it's by the preponderance, he has to prove, whatever it is, it doesn't really matter, but he has to basically prove to the court that he is likely to win, that he has a good chance of prevailing on the merits. If you can't do that, then the court just immediately dismisses the case, probably with prejudice. I'm not entirely sure, don't really care. But the point is that the anti-SLAPP statute serves a couple of functions. Number one, it gives people a quick and easy out if the lawsuit doesn't have merit. If the lawsuit has no merit, they say, Judge, the lawsuit has no merit. The other side has to show, wait, it actually does have merit. And if they can't, well, lawsuit's gone. Saves the defendant money. And equally important, it gets rid of a lot of shit lawsuits out of the courts. The courts are finite. They only have a limited number of judges with a limited number of days, limited time in limited courtrooms. It's not infinite. Courts are backed up. Courts push things around and try to squeeze things in and try to pressure parties to settle because courts are backed up. So it saves the courts. It saves taxpayer money. Think of it that way. For those of you who think, well, fuck the courts. It saves taxpayer money, because if we didn't do stuff like this, then we'd have to get more judges. We'd have to build more courthouses. We'd have to hire more staff, more bureaucracy to fill those courtrooms and courthouses with clerks and reporters and other bailiffs. We'd have to hire bailiffs for all these things. I mean, it just adds a lot of expense. So I think everybody can see that the anti-SLAPP statutes, the special motion to dismiss the case if the plaintiff can't prove by a reasonably high margin that he is likely to prevail on the merits, right? I think you agree with it. I agree with it. Well, let me introduce you to a cousin of the anti-SLAPP statute. This one was a judicial creation, but it is called qualified immunity. Now, it doesn't apply to just police. It applies to public officials generally. Anybody who's making decisions where they have to exercise discretion, they get qualified immunity. Now, qualified immunity doesn't mean they get away with everything. What it means is if the defendant asserts qualified immunity, it means the plaintiff has to show that whatever this right is that they're saying has been violated, they have to show that it has been clearly established in that circuit. Now, what it gets rid of is it gets rid of a lot of the shit claims. It gets rid of a lot of the shit complaints. If it hasn't been clearly established, maybe it isn't even a violation of a right. Because remember, you can bring anything as a lawsuit. You can say, I got tapioca pudding instead of chocolate pudding. That violated my 8th Amendment right as I'm sitting in jail. You could file that. And there's nothing stopping you from filing that as long as you can pay the filing fee. And even if you can't pay the filing fee, if the court allows you to file in form of papyrus or whatever they call it, then you could file it. And you're sitting in jail with nothing but time on your hands, and you can just run those bastards through the ringer. You could run your jailer, the warden, whoever, through the ringer. And it'd probably be the state. You'd be running the state through the ringer because the state would be the one probably footing the bill on it. So you'd be eating up court time, eating up state resources for the court, eating up state resources for defending, eating up state resources all over the place. So what qualified immunity does is it places a burden on the plaintiff up front just to show that they have a decent case. That's really what it is. Now, there are times, like Turner v. Driver, where the right wasn't clearly established. It's not often where there is a valid right that was being infringed upon that is not clearly established. It is not often where it's a valid infringement of a valid right that is not clearly established, because we have decades and decades of people with nothing but time on their hands filing lawsuits. Decades and decades. I don't remember exactly when 1983 lawsuits started, and I don't remember exactly when qualified immunity was developed as a doctrine, but I know it's at least been decades and decades. So there you go. Probably at least, I know it's been at least 50 years, probably more. So there's a lot of lawsuits filed all the time. So with that understanding, it is not something crazy that they just require the plaintiff to show that it is a clearly established right that has been violated. That should not be a bar to your case. And trust me, as an attorney, I don't care whether or not, from a professional perspective, whether or not qualified immunity goes away. Because there are two kinds of cases I would take where qualified immunity would come into play. Number one, as the defense. If qualified immunity was not a valid defense, I wouldn't file it. And if I'm on the defense, guess what, kids? I'm getting paid by the hour. And if I'm getting paid by the hour and I don't get to dismiss the case summarily, and I actually have to take it to a deeper level, maybe go for a full motion to dismiss, or maybe we have to go through discovery before I file a motion for summary adjudication. I don't remember what they call it on the federal court level, but you get what I'm saying. Then I have made extra money. It is good for me. Billable hours, baby. The only other case I would take where a qualified immunity defense could come into play is if I was for the plaintiff. But now there's two ways that attorneys take cases for plaintiffs. One is contingency fee. That's generally speaking where the attorney thinks the plaintiff has a good case, and where the attorney believes that he can make more money on a contingency than he could if he was taking it hourly. Good case, good payout, you're looking at contingency fee. On the other hand, bad case and or bad payout, you're paying hourly, son. And in that case, if there is no qualified immunity, the case goes on longer and I get paid more by the hour. So as an attorney, it doesn't hurt me. What it does hurt is it hurts the taxpayer. It hurts the police. And I know there are those of you who think, well, fuck the police. Well, that's about the dumbest fucking thing ever. And we're going to see that. Minneapolis has decided that it's going to abandon its police force. It's going to dismantle its police force. One of two things is going to happen. Number one is the county level, whatever that is, the sheriff. I don't know what they call it out there. Somebody from the county level is going to step in and assume the policing functions that were at one point in time taken up by the city of Minneapolis. Or number two, people will start hiring their own private security. And it's going to be a case of the rich people have private security and the poor people don't. And then the poor people are going to clamor for universal security. For universal security, aka the police. I mean, the writing's on the wall. And if they don't do it, if neither of those two things happen, what you're going to see is a mass exodus. You're going to see businesses leave. If there are no police, there is no protection. If they can't hire their own security that has the same powers as the police, the powers to arrest, the powers to use force, then they won't be able to protect their products. They won't be able to protect their livelihoods. There is no reason for them to maintain a business if they can't make a profit. If they can't feed their families, if they can't pay the employees to work there. If everything gets stolen out from under them, or even if too much gets stolen out from under them to make it profitable, to make it not profitable, they're going to leave. Families are going to leave. People want security. I know there's a small segment of this community and a small segment of the country who has bought into the whole delusion that the police are the problem. But it's, number one, it's not a problem. And number two, the vast majority of Americans favor either keeping the police forces the same or hiring more police. Something like 90% of Americans think that we should either keep the police forces the same, keep the same amount of police on the streets, or increase. 90% of Americans. There's about 10% out there right now who are rioting and protesting and calling for defunding the police or abolishing the police. It's ridiculous. And for those of you who are thinking police are a problem, police brutality, police violence is a problem, you know, the last year that the FBI has complete numbers for is 2018, and the FBI numbers show about 9 million, a little under 9 million arrests in 2018. Now, those aren't the complete numbers, because not every police station reports to the FBI what arrests they've made. So it is an incomplete data set, but we do know that there are at least 9 million arrests that were made last year, or 2018. They don't have 2019 numbers yet, or at least they didn't when I checked. So, sorry. Now, the Washington Post or the Washington Times keeps count of every person killed by the police in the US. So their count is complete. And for 2018, they had 992 people. If you do the math, that is less than 1 in 10,000 arrests. Less than 1 in 10,000 arrests results in someone dying from the police. Less than 1 in 10,000. And that includes all the arrests that are made where people are shooting back at the police, where they're holding hostages, where they're engaged in otherwise dangerous activities. It's where people are killed in car accidents, running from the police, where the police use pit maneuvers and the police cause their death. I mean, it's all that stuff. It is all that stuff. Less than 1 in 10,000. The best way that you can ensure that you don't die at the hands of the police, the best way is if you don't resist arrest. I can't stress that enough. If that makes me a bootlicker, fine. That's a bootlicker trying to keep your dumb ass from getting killed. And I know I'm going to get people in my comment section pretending to be keyboard warriors, and I know what you are. You're a stupid, dumb shit keyboard warrior, and I don't believe a word you're saying. Because you're still free and you're still alive, which means you're not out there resisting arrest. So go tell it to someone who's going to buy the bullshit you're selling. Anyway, hopefully all this walking has taken the edge off and I'll be able to sleep. Maybe, maybe not. Who knows? Thanks for watching. Have a great weekend.